the food, and they said there's no variances required.
Matter of business before we continue, if that's okay with you, Ms. Jennings?
I make a motion to reopen the meeting. Sullivan?
You need a second?
Second.
All in favor?
Aye.
Thank you. Mr. Alfieri?
Hi, Madam Chair, members of the board. I have the two minor subdivisions that are on at the end of the agenda, and it looks like you're going to be a while on this application, and we're going to request that we be carried to a future date for both without the need to renotice.
Ms. Morrison, how are we looking? We're very
I
busy.
know. As long as it doesn't go beyond 2026.
It will not.
Hopefully not.
It will not.
Let's see. We have one application on for May 18th, right now.
What's the
It's a-
application?
It's mine.
It's the daycare center.
It's yours.
How about that day?
How about that?
That would be, let me just check with my professionals.
May 18th?
May 18th would be perfect for both, please.
All right, I'll take a motion to reschedule this, Mr. Alfieri, for May 18th.
I'd like to make a motion that we reschedule block 8901, lot 5, additional lot 4, Joseph Chaim Minzberg, to May 18th, 2026. And also block 8901, lot 19, Joseph Chaim Minzberg, to May 18th, 2026.
Second.
All in favor?
Aye.
Thank you,
The
Mr. Alfieri.
applicant grants time of extension.
Yes, the applicant will grant an extension, and would you please announce that there won't be an additional
No,
notice?
no public notice.
No notice
Thank you.
required.
Thank you, good night.
And so anyone who is here for those two applications, if you could just leave quietly, we'd appreciate it so that we can get on with our business for tonight. And thank you for enjoying what we do here at the Planning Board. All right, we're back in session.
Chair.
Now we have,
Madam
Mr.
Chair,
Brezzi has a question.
to the architect, ma'am, you stated about the floor drains. Did you say you're going to have floor drains?
Yes.
Okay, I have a problem with that. That's only me.
Okay.
There's going to be vehicle maintenance in there. And where is your floor drains draining to?
Well, we'll have to coordinate once we get the MP engineer on board, who would coordinate with civil. But typically, again, we could look into it, but typically when there is vehicle maintenance, floor drains would be required. But again, if it's not required,
Well, and typically on a couple of years on this board, when there was vehicle maintenance inside, we didn't require floor drains. For the purpose that we don't want it laying out in the street and ruining the ground and everything else. So if you're going to have floor drains, we're going to need something detailed on where those floor drains are going,
Of
how they're
course.
going to be cleaned, how it's going to be picked up.
again, and if
I
they're not
think that's got to be
required.
addressed before anything else gets addressed in that warehouse.
Madam Chair, if I just could chime in from engineering.
Yes, please.
This raises a concern as far as the stormwater drainage, and are these floor drains going to tie into the storm sewer system? The answer to that question is no. But it's kind of a critical item as far as I'm concerned.
And I think it's going to be a serious problem for the environmentalists as well.
Correct. No question.
Correct?
Correct.
Correct. So I think you might find a workaround for the drainage system you use. I believe there are portable workarounds.
There's a lot of workarounds, how it's caught, but then how it's removed. You have to have, receipts every time the stuff's removed. I think Mr. Tremor can add to this. There's many ways to do it, but we have to make sure it's in place. Because if you're changing oil fluids in that warehouse and it goes into the regular system, it's going right out into the grounds. We can't have that.
I
Let
would
alone
like-
the stormwater system, it's just going into the grass and stuff. You can't have it.
I'd like a little bit more detail on it. I agree with Mr. Presley, there are mechanisms that can take care of it, but just to say we'll do it later.
Well, I think it's more of a building code issue, and we'd have to follow the building code. The building code isn't going to allow you to do that.
I think it's more of an environmental issue, which I think falls with this board.
Well,
So-
no, again, environmental is not part of the board's jurisdiction.
So
No, no,
will
no.
the applicant agree to a condition of approval whereby the oil is not put into the ground, they'll remove it off-site?
Correct.
And we'll get some final detail of that as part of any approval the board may grant.
Yes, that would be part of the conditions of approval. Yes.
Okay, so just for my justification, if it's part of their approval, if Mr. Klee is not satisfied with the details of it, they have to come back in front of us?
Correct.
Thank you.
Mr. Klee, you're the bottom line,
That's fine.
The
as
applicant-
usual.
The applicant agrees to that condition.
Correct.
Okay.
Applicant will agree to that condition.
All right, we're sorry to have interrupted your presentation.
No problem.
Do we know where we need to start? Do we have to start over at all, or
No,
no?
So the YouTube, so it got a little complicated. The hearing itself was being recorded, but the YouTube audio wasn't on when we restarted. So now it's got both. So if you want to backtrack by a couple of minutes, go back a few points, start there.
Okay, I guess, should I start with the warehouse?
You
Go
do
back
that,
to the warehouse? Okay. So the warehouse consists of a new construction, single-story warehouse, no basement. The floor area is 12,352 square feet. The warehouse is divided into 4 bays. The warehouse will be occupied by a single tenant, and the division was just to create some separation between uses. The warehouse will be used to store and maintain vehicles and for storage purposes. The common area in the warehouse includes bathrooms and utility spaces. There are 2 overhead doors in each bay. And in terms of the exterior material is corrugated metal siding with a sloped roof. And the building height is 22 foot, 11 and a half inches. A sprinkler system will be provided throughout the building. There is no signage on the warehouse. And if we could pull up the site rendering. And I'll just go into a little bit of detail into the 2 storage sheds.
That was A2?
No, not the, we have it's A5. In terms of the storage shed, so we have 2 storage sheds on the site. pipe storage shed of 810 square feet and a 1575 square foot storage shed used for accessory office storage. There are 3 overhead doors in the pipe storage shed and 2 in the storage shed. The exterior materials will be corrugated metal siding with a sloped roof, and the height of materials will match the warehouse. There is no building signage on any of the sheds.
And then again, just for the record, the pipe storage shed, that's to hold the piping,
Correct.
and that's related to the warehouse use?
Yes. You just see the rendering here. We're showing a bird's eye view of the full site. So we have the office building with the accessory storage shed, and then the warehouse in the back with the pipe storage shed.
Mr. Chairman, may I ask a question? When you have these off-site buildings, would the fire department prefer that there's a number on those smaller buildings so that if the fire department is called, they know to go to building 2 or building 3 or?
Yeah, so that's ultimately going to come down to Mr. Roush and how he deems it to be labeled. I'm assuming that all of those buildings are going to be alarmed and have suppression systems in them,
So the 2 storage sheds are not required to have fire suppression.
but they will be alarmed.
Fire alarm?
Yes.
Fire alarm is not required in those either, based on the size and the use.
Mr. Roush cleared those?
I mean, building code.
Yeah, and
Clear
I mean, we
those.
have his review letter.
Would the
How
applicant
about,
be
how about the
amendable?
numbering?
I mean, typically, as a first responder, we would like to see buildings be labeled. So that way, when you do get some sort of incident in one of these, it's better to be, to play on the safe side, it's better to be clearly labeled.
Even if it's building A, B?
Building A, B, or
That's
C,
fine.
yeah.
Sure, we don't have any issue with that. We can label the buildings.
Thank you. Continue. Thank you.
I think that's it.
That's it. Okay. Questions from this board?
What's the square footage of the shed?
So we have one that's 810 square feet, which is the pipe storage. The other one is 1575.
The one in the back.
Just to give some context in terms of fire suppression or fire alarms even, the building code requires fire alarm systems when you have an occupant load of 500 in a warehouse or 100 above the lowest level. So we're significantly lower than that in those 2 storage areas.
Understood.
There won't be any flammables stored in
No.
these buildings, correct?
Correct.
Thank you.
Question. On the height of the office building, you have it up at 42 feet plus the parapet of 3. I thought there was no variances required.
So it's 42 feet. Parapets are not included in building height.
I
And
understand that, but it's 42 and 3, isn't it?
it's 42 feet, even if you included the 3, which is not included, it would be 45, which is less than 50.
I think it's a third. Oh, in this area. Sorry.
No problem.
Good. Any other questions from this board? From our esteemed professionals?
Thank you, Madam Chair.
Mr. Clee?
Just a quick one. In this elevation or rendering view, I can kind of see the storage shed, 1575, and I kind of get answers my question as far as how you get into it. I see 2 garage doors in front, and I guess the testimony was that the parking spaces in front of them are going to be designated employees.
I believe Mr. Portnoy testified that he could remove some of the parking to provide access.
Yeah, we're over parked, so we were going to remove 1 or 2 of them so that there would be direct access and nobody parking in front of them.
And there'll be some type of pavement connection between the parking lot pavement and the parking.
We said we'd do a crosswalk hatching.
All right, thank you.
Thank you.
Madam Chair,
Yes, sir. Mr. Peters?
thank you for your testimony. With regards to the elevator, is there a penetration through the roof for the elevator system?
No bulkhead.
Okay. The preliminary elevations show signage of some sort. You just indicate that the proposed building signage will meet the ordinance requirements, and you're not asking for any relief?
Correct.
Thank you. That's all I have, Madam Chair.
Thank you. I noticed that the first rendering we received had 2 signs. The
We
second,
adjusted.
you
yes.
adjusted.
Mhm.
Thank you for doing that.
No problem.
Appreciate it. Anything else? Thank you.
Thank you.
At this time, I'm just going to call Joseph Portnoy back up, just to address the accessory nature of the 2 sheds so the record's clear.
Excellent.
Because
Thank
he
you.
does have a planning license, so maybe requalify him as a planner.
You swear or affirm to tell the truth, the whole truth, nothing but the truth.
I affirm.
All right. And you're
Thank you, Mr.
retestifying as a
Portnoy.
planner.
Okay, and Mr. Portnoy, you heard the testimony given here this evening and the question placed on the record by the board planner with respect to the 2 storage sheds. Can you just, from a planning perspective, indicate, in your opinion, whether the storage shed for the office building is considered accessory and whether the pipe storage shed is considered accessory to the warehouse use?
Yes, based on the testimony, is my opinion that each of those sheds are accessory to their respective uses.
Okay.
You want to go into a little bit more detail or?
The storage shed and the pipe storage shed is accessory to the warehouse use, which is similar storage of materials and equipment. The pipe is another form of material that just requires a little specialized storage just to based on its the size and shape of it. And the storage shed in the front in the office area is accessory for equipment and materials associated with the office uses.
Would the storage shed in the front have lawn maintenance or building maintenance materials in there? I'm concerned about flammable situations.
The testimony was that there would be no flammable materials.
All right, so
stored.
there will be no snow blower, no mowers, none of that kind of thing in there, just office supplies.
Right, correct.
Thank you.
Thank you.
Any other questions? I think that's sufficient. Thank you.
Thank you.
And that's essentially our direct testimony.
I think it's time to call the public.
I'd like to make a motion to open this to public cross-examination on this application and this application only. Sullivan?
Second, Pella?
All in favor?
Aye.
Explain the circumstances of the cross-examination to the public for this portion.
Okay. All right. So here's where we're at. So we are opening to the public the cross-examination portion of the application. So any questions you have for the experts that testified, you're more than welcome to come up and cross-examine them. Based upon the recent appellate cases that we've had, I'd just like to indicate that if I feel like we've already put the testimony on record and there's already, if the record already reflects the point you're trying to get across, I'll simply just say asked and answered, and we can move on, because once the record has that objection, the record keeps that objection. So there's no reason to kind of go over the same thing 7 or 8 times. So anybody who wants to come up, more than welcome to.
Good evening. I just want to
Good
say
evening,
that
sir.
you're-
You'll be sworn in by
Oh,
the,
yeah,
Yep. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I don't.
All right, please state your name and spell your
And I do want
last.
to say your YouTube is broken. It's been broken for, I don't know, a while. So just letting you know
It's still?
whether that impacts anything or I don't know.
All right, what-
we're under different rules than the council.
Well, that's up to you. I'm just letting you know.
Thank
That's
you.
all.
We
I'm not
appreciate
making
it.
it.
You have to give your name and spell it for.
My name is Paul Revere. I'm on West Commodore Road,
Right.
Boulevard in
It's
Jackson.
working. We have it on, we're hearing it.
I'm sorry?
We have it on,
The YouTube is working now, sir. It's fixed.
I'm sorry?
The YouTube is fixed now.
Okay, well, I'm just saying you had a blank period, whatever, you know. All right, my question is,
To the, one of the people who gave testimony, sir?
well, you had, my question is to our own experts.
Sir, our questions at this particular time are to the people who gave testimony. Later, you will have an opportunity to speak, giving a statement or asking questions of us.
So-
All right, I just want to ask the planner and the engineer a question.
Not at this
So
time,
we-
sir.
we-
This is only cross-examination of the people who gave
If you
testimony.
if you have any questions as to anything that they testified about, you can maybe take the same question
Well, when
directed.
can I ask them questions?
So,
Next
on their
period,
reports.
at the next period.
What's that?
so
The next meeting, you're saying?
No,
Oh,
the
no.
next
all right,
section.
Oh, the next, okay,
hang on, guys.
all right.
So just to be clear, our professionals don't testify on behalf of the applicant. So if you have questions regarding the use, what they put on record, you can kind of reverse engineer what you want by
Right.
asking the board or the applicant's professionals.
Well,
if that makes sense.
our professionals have made statements, and and they've provided reports that each and every one of you should read. And I have questions on that.
At the
Okay?
next session.
Okay,
Thank you.
all right. Now, I guess I just want to clarify, is there an approved LOI on this application? When I say approved, it's either some government entity that said that they agree with your environmentalist LOI.
Yes, we have the Pinelands Certificate of Inconsistency, which confirms the wetlands, and they're the ones with jurisdiction.
All right, so what was that again? You said that you do have an approval of the LOI that's in this application?
So you want me to, all right, so, and I'll.
You know,
Hey, let me just kind of set.
now I
because-
can't ask you this lady question.
No. Let me
Okay,
kind of,
all right.
let me explain the situation to you. So we have a situation here where there's an applicant that's in the Pinelands, right? The Pinelands is in the conservation overlay zone. What happens is that the conservation overlay zone requires an LOI, right? But the Pinelands, because they're the governing jurisdiction, the certificate of filing is the equivalency of the LOI, right? Because what happens is that when you're in a Pinelands jurisdiction, Pinelands subsumes the jurisdiction of the DEP. So the certificate of filing becomes the LOI because the Pinelands are the ones who are in control. So basically any habitat, any tidelands, or I'm sorry, any wetlands, anything like that, anything environmental related, the Pinelands Commission has final say on all of it because it's the Pineland zone. So it's a little funky because you have Pinelands and non-Pineland zones in the conservation overlay area. So it gets a little confusing, but that's where we're at. So what happened in this situation is that the certificate of filing is the LOI. They then got an either more enhanced version of it, which is called the letter of inconsistency, which set forth all the things that they have to correct on their property. And then what happens is that after this, they then have to go back to Pinelands Commission, rectify all those problems, get what's called either a no callback letter or a no further review letter. So it's kind of, this is a tricky situation.
Well, thank you for that explanation. However, I still like to clarify that the Pinelands approved the LOI. That's my thing.
There
'Cause
is no
what I'm
LOI.
saying is that their environmentalist their LOI is best case for the applicant. So when the government looks at it, they might say, oh, that's no good. We want that, you gotta move that forward 100 feet. There's give and play on this. Okay, and 100 feet could make a major difference in this application.
So what happens is that the Pinelands is now in control of the wetlands delineation line. So they're the ones that now, they retain jurisdiction over it because it's in the
Yeah,
Pinelands.
but
So-
you're still not answering, Mr.
No,
Shea.
I'm trying to answer you. So it's confusing because what happens is that the LOI is only for a DEP issue, right? So that the essence of an LOI is to figure out what the delineation line is for a wetlands area. So what happens when you're in a Pinelands area, you don't file that with DEP, you file that with
I
Pinelands.
understand that.
Right, but that becomes a certificate of filing.
But do you understand my question?
No, I get you.
My question is, have they approved an LOI yet? I mean, where they say, this is it, this is the official LOI.
The buffers are approved. If you
Right.
read the Pineland certificate, it tells you where the buffers are from the wetlands off-site. No wetlands on our property, but we have the buffer from the wetlands off-site. And that was the wetlands line that the site engineer went through twice, under the existing conditions and under the proposed conditions.
Okay, well, I was just trying to clarify that. I'm not trying to go
No,
back
no,
and
it's fine.
forth.
Do you want to ask the engineer any of those questions or?
Yeah, I would also, would you accept the board, the planning board, giving you a preliminary site plan approval, and then coming back after all this is settled, all
Yeah.
this?
No,
That's
there's
not how
the
it works.
board, we don't have any special relief that we need from the board, so we would get our final approval. That's what we would like. And it would be conditioned on getting all outside agency approvals, including, most importantly, the Pinelands. And we can't do a thing until the Pinelands signs off.
No, I understand that, but if there's major deviations, what happens?
We know where the buffer is because we already did that step. That's done.
Okay, all right, well, those are my questions, okay, and I appreciate
So,
your explanation.
what happens is that if there's any deviations whatsoever from the wetlands delineation line, then they have to, number one, they'll get, they'll have a public hearing at the Pinelands Commission regarding that issue because they'll most likely get a callback letter. But also the approvals that, if anything happens tonight, this will be null and void, and they will have to come back for board approval if the wetlands delineation line has changed.
Well, that's what happened with the applicant, and
Yeah.
the people, out in the back of me, there was a assembly full. They don't trust anybody to not stretch the laws and the rules.
Sir,
and
this
say
is
we
the
don't need it.
this is the time
Yeah.
when you may cross-examine. You may discuss these things at the next session.
I'm just telling you that the people feel better if they can see the final environmental lines and not worry about
We
somebody
have the
else.
final
Right.
lines,
Okay.
sir. They're in the
All right, well,
plans.
thank you very much.
Thank you. For cross-examination purposes, please? Thank you.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right, please state name and spell your last for the record.
My name is Tom Smith, SMITH. Our residence is at 520 Whitesville Road. It's directly adjacent to the south side of this application. I have some questions, I guess, for either the applicant or the applicant rep.
At this point, it's just for the applicant and
The
the
applicant rep.
engineer, the
Yitzi,
planner.
come on back
the-
up. Or Shlomo, you want to come up? Shlomo wasn't sworn in yet, so you'd have to swear him in first before he can answer any questions.
All right, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right, please state your name and spell your last for the record.
Shlomo Horowitz, Horowitz.
Okay?
And just for the record, can you say how you're affiliated with the applicant?
I am the owner of the property and the company Atlantic Site is my company.
Okay, just want to make sure he was qualified to answer the question, so go ahead, sir.
Okay, so Atlantic currently owns and controls the property, correct? And Atlantic's a heavy equipment and paving company?
We do have, heavy equipment work. We don't do our own paving. We do small, very small paving jobs.
You sub out paving?
Yeah, we do a little bit of like restoration work, but the heavy paving work we sub out.
Okay, all right, because previously there was an application for a paving contractor on this same site, and I'm sure you.
Sir, I'm having trouble hearing you, and so the
Okay.
public might be having trouble hearing you as well.
Okay, sorry.
That was the previous owner. It was owned by Justin, his last name, of Elite Paving.
All right, but Atlantic currently operates at 688 Cross Street?
Correct.
Okay, because the
668.
testimony was that the choice of this site was to accommodate the employees, that it's close to the area. So you're moving the business from less than a mile away to this site, correct?
Correct.
Were you subject to any land use violations where you're currently operating from in Lakewood?
I do not believe so.
And that's irrelevant to the application in Jackson.
Yeah. So what happens is the planning board doesn't have the ability of taking into consideration what's called policing actions. So anything that happens outside jurisdiction of the township, violations, policing authority, policing powers, that's an executive branch function. We don't have the ability of taking that into consideration
Understood,
for.
there wasn't testimony to where they're currently.
Yeah, I'm
operating,
just
so,
saying
yeah,
what we
I
have
get that.
jurisdiction. Yeah.
I do have a question, I guess directly for you. I have a question on their operation that they're going to move to this site.
You can.
I'd like to base my question with a photograph. I have copies for the board if this is the time to hand it out, or I could come back with that question during the questions directly to the board.
I would say he has to come back if he wants to put on testimony and be subject to cross-examination
Yeah.
later.
So if you
I can hold that, that's fine.
if you want to put that during the public comment portion, and then we can submit it as an exhibit.
All right, well, based on that, I got to skip several questions till I come back. If you just give me 1 second here. The exhibit, actually, that's up, shows one dump truck on the site. How many dump trucks does the company actually own?
The company, I'm not exactly sure, but I think it's about 8, 9 dump trucks right now.
Okay, well, and it's not significantly more than that. You have an off-road Moxie,
We have an offer outside. I didn't hear what you
you know,
said.
the off-road articulating dump truck?
Yes, but
You have
yeah,
that?
yeah. They generally don't come to my sites unless I'm repairing them.
Okay, the testimony before was that most of your equipment is actually on job sites and not
Correct.
residing. Okay, I don't know if that's appropriate to base your application on your equipment. You own it, you have to store it somewhere, but you're saying it's off sites. So that would be a question for the board later. Especially if,
So just to be clear, so any questions you have as to operations, now would be the time to ask the applicant's experts. Yeah.
you and probably also your counsel here, your representative, 244-197 off-street parking for non-residential development. I just want to see if you've considered that, because failure of an applicant to indicate where applicable in a statement of operations that vehicles larger than automobiles are to be parked and stored on site for such parking and or storage on this, have to be on the site plan. And if they're not on your site plan, the parking for these vehicles, that's actually a violation in the application. So I just want to point that out.
The application meets the parking requirements. We actually exceed them.
I didn't see any dump trucks on the application, or any large off-road vehicles or large construction vehicles.
I believe there was testimony on the types of vehicles and the number of vehicles and the size of vehicles. I believe Mr. Marzo asked that question, and it was answered by the applicant.
Correct, and it was that there would be essentially two pieces of equipment. kind of
Oh,
coming
no,
on
I
the
believe
site.
there were something like 8.
So why don't we let the applicant testify as to, so
Okay.
Ms. Jennings, if you have whatever expert testify as to,
I can speak to that.
Well, he's
I
the
can speak
owner.
to
He
that.
can speak to it.
Right.
So there's equipment that's being worked on, that's being stored indoors, and as an overstock, there's going to be some equipment that's going to be stored outdoors. What there will be, this is a guesstimation, about 2 pieces of equipment that will be going in and out of the site every single daily. Just on when something's ready to be going, when something's finished being repaired, it's ready to go back onto the sites, it will be exiting, and then we'll have additional pieces that, on average, again, that will be coming to the site to be repaired and maintained.
Okay, so you could have up to 8 dump trucks parked on the site. in the
Correct.
site
We
plan.
currently have about 8 dump trucks
Okay.
in operation.
Is it possible to bring up the stormwater plan? I just have one question about the stormwater plan, and the
The,
engineer could probably answer it from.
Thank you.
afar.
thank you. The
We'll
first,
bring Joseph up
Yeah.
for that question.
I just have a question about what the scour holes are, particularly on the plan scour hole number 4, because it looks like it's an overflow point from the stormwater basin.
The scour hole is located at where you have an end of a pipe. It's so water exiting a confined pipe spreads out and does not cause erosion. So we do have anytime we have an end of a pipe, we'll have a scour hole or some type of energy dissipation.
Yeah, I couldn't figure because scour hole 4 looks like it's connected to the front stormwater basin. And
Yes,
then it comes right to our property line as a scour hole. And I didn't know if that was a discharge or not.
there is a discharge there. There is a discharge. The basins have been designed to fully infiltrate, most storm events. But in a large storm event, there is a head wall there for an overflow discharge. The discharge locations are based on where the existing topography is and where water flows now. And reviewed, besides for this board's professionals, they're also reviewed by a soil conservation district and the Pinelands to make sure that we're complying with all of our requirements. Any water being discharged, we have a requirement to reduce our peak discharge. So we have to analyze what water was going there previously, and we have prescribed reductions that we need to make on those. And additionally, the Soil Conservation District makes us account for a failure analysis if our basins would fail until to demonstrate there will not be an impact to adjacent properties even in such an analysis.
Okay. On this exhibit, in the stormwater flow, outside of the warehouse building, all of that stormwater is captured in basins and directed to the stormwater basins, correct?
Correct.
Okay. I'll come back to the board with that because that's actually going to be an issue. Everything I have has been answered for this. I'll have to come back with it.
Thank you, Mr. Smith.
Hello. Why did you just shake your head at me?
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Adam Heidi.
And were you here when I discussed the?
Asked and answered?
Yes.
Yes, sir.
Good. Okay.
We should name that the Adam Law.
That's it.
All righty. My first question,
If you could move that microphone so that we can hear you better. Thank you.
is this
And
a
the
little better,
people-
Ms. Chairman?
Oh, much better. Thank you
Perfect.
so much.
Absolutely. My first question's about the location of the property. This property is located in the conservation overload zone, correct?
It is within the overlay zone, correct?
Okay. Are you familiar with our township ordinance 24445 about the
Yes.
conservation overlay zone?
There is that ordinance as noted is in the non-Pinelands section. So that ordinance section does not apply to this property.
Okay. Can you point to where in 24545 it explicitly states if the zone, can you point to where in 24545 it exempts your parcel from an LOI from the DEP? And for the record, I'm going to give the applicant our ordinance.
It is, I have a copy, thank you. Yes, it is in Article 6 titled Non-Pinelands Area Zoning District Regulations. So
Is this within 24445?
that 244-45 is within Article 6.
Okay, continue.
And therefore, the entire ordinance section does not apply to our site. Nevertheless, our wetlands were verified by the Pinelands. It is not possible to get an LOI because the LOI is issued by the Department of Environmental Protection, who does not have jurisdiction over the site. But we do have confirmation of the wetlands from the Pinelands Commission.
Can you read me explicitly at Article 6 where, can you please read that? Because I don't see anything of what you're saying.
It's in the overall heading of that.
Can you point to where in the ordinance specifically?
Adam, it's judicial notice. You don't have to, you don't have to recite
He's
the,
not citing anything
you
specific.
you don't have to recite the ordinance.
For the
If-
record, the owner is not citing specific
If
statutes.
his testimony is to, it's not applicable, then he has to put the reasoning on the record.
He's not testifying to a particular ordinance, Ms. Jennings.
Right.
Is there anywhere in 244-45, the conservation zone overlay, that stipulates the Pinelands Commission trumps the authority of the DEP?
No.
Correct. So why wouldn't you need to file for a letter of interpretation? It has not.
So
Our ordinance explicitly states you need an LOI from the DEP. It specifically says the DEP. It does not mention another governing body. In fact, I would point for the record, 244-45, Section A, the intent and purpose. This was made in alignment, in concert with both the DEP and the Pinelands Commission. So neither or have Trump in power. It would be, Ms. Chairwoman, does your board trump the authority of the zoning board?
Adam, hang on. All right, so let me just,
Two separate agencies.
let me just
We are
go.
both municipal
Right.
agencies. You're talking about the difference between the township, the county, and the state. The state and the Pinelands Commission overrules the county and this township.
All right,
Okay.
so
I'll move on.
do you want me to explain?
The
No,
law.
I hear you.
Okay.
So an LOI was done, is what you are saying.
The wetlands were verified by the Pinelands.
The wetland delineation
Yes.
was done by who and then verified by who? So on your site plan, it states the applicant has delineated a wetlands buffer on an environmental constraints plan. That was done by professional design services?
Correct. It was
Correct.
prepared by a different firm.
Correct. I have that here for the record, this environmental constraints plan. Wetlands limit line as approved per 2014? Is this what you're referring to, this wetland delineation on your environmental constraints plan? I see wetlands limit line as approved per file number 2014.
We're talking about our Pinelands certification from December 24th, 2024.
Perfect. Does a certificate of filing contain a letter of interpretation, or is that simply a review of compliance?
I don't know. I feel like we are going around and around and around.
All right, so I'm gonna say, ask
Ms.
and
Jennings,
answer.
have you ever answered that
Adam,
question?
Adam, just hang on. Let me just explain like how this is operating,
I
right?
don't think you had the confidence to answer the question.
All right, so,
You don't understand what we keep
Okay.
telling you over and over and over again.
You're misspeaking.
okay,
Excuse me, really quickly.
one at a time.
The
Guys,
attorney-
come on. Let me,
Respectfully,
Adam,
Ms. Jennings,
Adam,
your applicant
let me
is
at least
stating
put
that
on
you have a
record what is,
delineation.
Adam, come on. You know, so here's how it operates, okay, is that we have a situation here where the Pinelands Commission subsumed jurisdiction over the wetlands delineation line.
I get that.
Right.
I'm s-
But
Goodbye,
it-
DEP.
So
I hear that.
I know that, but let me just explain to you how it's operating. So what we have in this situation is called a doctrine of legal impossibility, okay? You can't have an ordinance say one thing to a jurisdiction that doesn't exist when another jurisdiction is saying we're subsuming the responsibility of it, we're taking jurisdiction of it, therefore the certificate of filing is the same thing as an LOI, right?
That's not true. A certificate of filing does not
Okay,
include
so
an LOI, sir.
let's go back to.
And I can move on with that. That's, we can agree to disagree.
Hang on. Let's go back to first principles for a second, okay?
Okay.
So first principle is, what does an LOI do? All right? An LOI seeks a determination as to the boundary lines of wetlands.
Correct.
If Pinelands Commission is saying we are taking jurisdiction over that, then every single thing that would have been in an LOI is in the certificate of filing and the inconsistency determination, because they have retained jurisdiction over the first principle of whatever is contained in the LOI. So we can't, you're in a situation where it's legally impossible to comply with something that doesn't exist.
And what I'm telling you is I've reviewed their application, their certificate of filing. It does not include a letter of interpretation because that's not where that is not where letter of interpretations.
The Pinelands doesn't issue LOIs.
They can approve it.
They approve a delineated line.
Thank you.
But
Now
they
can-
do not issue LOIs.
Thank you. Now, can I move on to my
They
next
do not.
question? My point is that delineation was done in 2014 by Ian Borden at Professional Design Services.
Right.
It's on their environmental constraints plan. Is there an expiration on a letter of interpretation or a wetland delineation?
Let the applicant talk about the history
Yes.
of it.
Okay, so I'm going to read, this is a review letters issued by Pinelands during the certificate of filing process. So it's really subsumed in the certificate of filing, but in the review process, there's a back and forth. You know, they provide comments, we address them, and this is a.
And where do they approve the LOI? That was
This
done?
is a letter dated April.
No.
One at a time. Let him complete whatever he's testifying to.
This is a letter dated April 12th, 2023 from the Pinelands Commission. And I'm reading third paragraph of this review letter. We have reviewed the environmental constraints plan for the above referenced parcel prepared by Professional Design Services LLC and dated January 19, 2023. And then in the next paragraph, the wetlands line associated with the main stem of the Towns River to the southwest of the parcel as depicted on the plan is accurate. Additionally, the 600-foot buffer to the wetlands required by Jackson Township's Towns River Corridor buffer overlay is accurate and it's accurately depicted on the plan. This information completes the items 4 and 5 of December 5th, 2022 letter. So the Pinelands has reviewed the delineation of the wetlands and the buffers and confirmed that the plans prepared, the environmental constraints plan is accurate. And that was subsumed within the actual certificate of filing. We are under background, relevant information, the certificate of filing notes. There are wetlands within 300 feet of the parcel to the south and within 600 feet of the
Right.
parcel to the west.
Heard you. And what was the date on that again? The date of the letter and the date, what was the date of the letter?
The date of this Pinelands review letter, which is again one of the multiple review letters within the process, was
Yeah.
April 12th, 2023.
April 12th, 2023. And then the date on which the review was approved or the review was done, I think it was 2019?
I don't see a reference to a 2019. You may have been looking, it's referencing a environmental constraints plan dated 2023. It's possible there was an earlier version in 2019, but they approved the version dated January 19, 2023.
Interesting. On your environmental constraints plan, there's a wetlands line from 2014. Are you aware that LOIs and wetland delineations are valid for a period of 5 years?
That is correct in reference to the NJDP LOI. The Pinelands, makes their own rules and
with the Pinelands, how long are their permits valid for? Are you insinuating more than 5 years?
they have issued this now. So they've made the determination as part of this certificate of filing that they still concur with that line regardless of when it was originally delineated.
And just for clarification, they issued the letter of inconsistency, correct?
It's a certificate of it's an inconsistent certificate of filing.
Correct. Okay, thank you.
And that was dated December 24th, 2024, correct?
Yes.
For the record, our ordinance explicitly states an LOI is needed from the DEP, and I'm putting that on the record just in case for future prerogative writs. My question, my second topic is revolved around the use, Ms. Jennings. Application states this development is going to support a construction business. Is that correct?
Correct.
And where in 244-97, the Pinelands Manufacturing Zone ordinance, does it permit construction use? Could you point to any of the subsections in there?
They
that-
permit office and warehousing, and that's what we're doing there. Office and warehousing for a construction company.
Okay, does it permit any contractor use? Does the word contractor anywhere in the 244-97 ordinance?
No, but I'm not really the one who's testifying, so I'll have Mr. Portnoy testify to that.
May I ask, Anthony, can you bring up the documentation? It's titled 24069. It's one of the second to last attachments for this parcel. It says new warehouse zone and set. I believe the title explicitly mentions contractor shop. To my understanding, no contractor work is allowed in the Pinelands Manufacturing Zone. I couldn't find the word contractor anywhere in here. In fact, for the record, I'd like to make the board familiar. These are meeting minutes from 2020, August 19th. This explicit block and lot, block 22401, lot 7 through 12.
Going more
Adam,
towards
we're-
testimony
yeah,
now?
we're getting into,
Was denied
we're getting
due
into
to
general.
the lack of permitting a D1 variance.
Right, but
It sounds like,
Adam, you have to ask a question as to
I'm
the,
asking a question.
it's cross-examination. You're basically putting direct testimony on at this point. So just put.
If a use is not permitted in a zone, a variance would be needed, correct? Has a D1 variance been requested in this application?
No, we do not believe one is required. This is an office warehouse use.
I'll wait for Anthony to pull up the uploaded documentation from your applicant, please. That contracts your exact statement. In fact,
What exhibit are you requesting? All right. Adam, we have to have you on record, man. We got it. I know. Do we? Adam, please stop. Adam, please go up to the. I know. If you can describe the. Which exhibit are you looking for?
if you go to the planning board website, the uploaded documentation, there's I think it's the second to last link. It's an image of the proposed contractor shop. It explicitly says contractor shop, and I want that on the record. No.
Are you talking about the architecturals?
It says proposed warehouse.
It says proposed contractor shop / warehouse.
Okay, so maybe those were all,
Those might
if you
be
can show
old.
that to the applicant,
They're on the website. They're uploaded it. It was just uploaded.
if
It's
you can
not old.
show up to the applicant to see what he,
And actually, in the site plan,
It does say it.
hold on.
Here it is.
Anthony, it'd be really good if you could pull that up, brother. In the site plan itself, it mentions the intended use for a contractor shop. So there's two pieces of data that insinuate a contractor shop, but your use that you were testifying to doesn't explicitly state
okay,
that.
so we can put this to bed real simple. Does the applicant agree that this is not a contractor shop and it's just what was proposed on the application?
Correct.
The application explicitly states contractor shop. So whatever they proposed and written submitted to you guys, it
Right.
says contractor shop.
So then we're going to,
You might need to change your plans.
we'll do a condition of approval indicating that it's not for a contractor shop.
Correct.
Is the applicant's attorney familiar with the previous denial at this block and lot?
Never heard about it until this tonight.
For the record.
For the record, I didn't even know the client back then.
Okay. Would you like to know why the application was denied?
I don't think it's relevant. And
Adam,
you're testifying, and this is supposed to be cross-examination of our witnesses right
Adam,
now.
Would you be surprised if it was denied for a
Adam,
contractor shop use?
we can't take outside.
asking questions.
I know, but we can't take other applications from other jurisdictions and incorporate them into this one. It has to be what's in front of us.
You're an attorney, you know better, you can't repackage an application.
It's called res judicata, but
Thank you.
if it's a zoning board application and they're here in front of the planning board, it's a different type of situation. Right? So res judicata, like if they had applied to the planning board, got rejected, came back with the same type of plan, then that would be a res judicata situation. But if it's a different form of variance in front of a different board, it's not.
Okay.
Right?
What kind of vehicle repairs are going to be taking place here? One of the applicants, somebody mentioned vehicle repairs.
Yep, no, one of them will come up and answer that.
Okay, thank you. Was vehicle repairs in the site plan report? Or was it testimony will be provided?
Go ahead, please.
Just say no, it wasn't there. Were any vehicle repairs, was the vehicle repair intended use included in the site plan report?
I don't.
I'm not a liar.
No.
It wasn't. I mean that.
I don't know exactly what it says.
Okay,
Let other
one
people
at a
weigh in
time.
on that. I can talk about what's relevant to me, but
Okay, so what's the question?
The question was, what kind of vehicle repairs are taking place? One of
Okay.
the team members mentioned, we'll just be doing vehicle repairs, probably in the contractor shop. But no, I just want to get clarification.
It can't be any more because we just put a condition of approval in there.
Well, there's so many conditional approvals, you deny it and they redesign a site plan, they come forward with an actual plan that is permitted based on our ordinances.
It's gotta be permitted.
15,000 conditional approvals.
It's got to be permitted. That's why it's
There's
here.
ordinances for a reason, respectfully.
I know.
Res judicata.
Called res judicata.
So just so the record's clear, thank you, Joseph. So section 244-97B says, as following accessory uses shall be permitted in the P1 Pinelands Manufacturing Zone. Private garage space necessary to store or repair any vehicles associated with the permitted principal use on the premises. So I don't think we need to spell it out.
What section is that?
244-97B. I'm looking right at it.
Okay, private garage space? Is this going to be private garage space?
It's a private business. Yes, it's not open to the public.
Interesting. Interesting. Okay.
All right.
I may have came a little late. Did the applicant testify at all towards the outdoor use? It's believed that they have some plans of storage outside the warehouse outside?
Yes, we did talk about that.
Are you going to ask them to answer me?
And I would refer you to ordinance section 244-97E6, which does say all industrial activities process shall take place in a completely enclosed building. Incidental storage out of doors shall be shielded from any street or adjacent residential zone by fencing, landscaping, or other appropriate measures. We indicated we'd have like two things stored there while they're waiting to be repaired and then be removed from the site on a daily basis. So I think that we're fine with that.
Okay. One last question. All over the site plan and throughout your testimony, you guys have stated there are no wetlands on the site. Are you 100% confident there's no wetlands on the site, on any of the 6 sites?
Correct. 100% confident. There are wetland buffer lines on the property, but no wetlands.
So you're saying on all 6 lots, there are wetland buffers, but no wetlands? Is that correct?
I'm going to let him answer one last time, and then this is over.
I just would like to submit.
I know.
We only have 2 lots,
Ask
so.
and answer.
No, it's 7 to 12.
7 to 12.
The wetlands were verified by Pinelands. The Pinelands has verified there are no wetlands located on any of the subject properties. There are off-site wetlands with buffers that encroach on the property.
For the record, this map is from the Pinelands GIS. All 6 of your lots are listed here.
Okay, again, he's testifying. He's not an expert. He's
Right.
using documents that no one's seen. Can't allow that.
For the record, confirmed
So-
by the Pinelands
right.
themselves, there are 3 wetlands on.
Adam, asked
6
and
of the
answered,
lots.
asked and answered. It's the Pinelands is going to determine all of this. And they may have somebody go out to the site and walk the delineation line themselves if they think it's needed. That's how it operates. Either have an engineer do it privately, or either the DEP or Pinelands send somebody's out to either rescope out the line or do it themselves. So this is way beyond our jurisdiction.
For the record, the applicant stated there are no wetlands on all 6 lots.
They've already
Correct.
testified to it.
Correct? Great.
Yep.
Thank you.
Anyone else would like to cross-examine?
Seeing no one come forward, I move to close the cross-examination portion of this application. Sullivan.
All in favor?
Aye.
Aye.
I'd like to now open the public comment portion of this application and this application only. Sullivan. Aye.
Someone would like to come forward now?
And just per usual, we're going to limit it to 5 minutes apiece. We'll go from there. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Please state your name and spell your last for the record.
Tom Smith, Smith.
All right.
As I alluded to earlier, I have a photograph I wanted to share with the board and then use it to ask some questions of the applicant if they choose to answer them. Can I just hand these to the end there?
So if you want to, if you can submit it to our board secretary, we'll make it as a exhibit, and then she can send it around to the rest of us. So we'll make it 01.
Okay, first comment to the board is in the PM1 zone, this is not an accessory use, and this is almost identical site use with the heavy equipment, excavators, dump trucks. They say their paving is subcontracted out. That was not permitted previously by the zoning board and was denied a D1 variance. This is essentially the same application. I want to use this exhibit photograph to show exactly what my concern is and what I'm talking about. With the current operation that's being proposed to be moved onto this site, because their current operation does not match what we're showing in these exhibits, and I just want to make sure which one's going to actually exist on the site. This exhibit, which I would have no problem with, or what their current operation is that they want to move over. I did testify that they do operate at 688 Cross Street. So I'll wait till they get across, or I've got a 2023 photograph, aerial, Atlantic site construction of the front part of the site.
Right. So just to be clear, so where did you get this from? Where is this from?
This is Google Earth, publicly available aerials. Anybody can look at them.
Okay. All right. And where is this located?
I'm sorry?
Where is this located?
This is 688 Cross Street. From the site on Whitesville Road, you can go down Faraday, make a right. It's immediately right there. It's probably half a mile away from where they
Okay.
want to move onto Whitesville Road.
And what are
If you look at
you saying this came from the zoning board application?
I'm sorry?
Are you indicating that this came from
I
the
am
zoning board
discussing
application?
what their current operation is that they want to move on to this site.
But we just had a whole
So,
hearing about what we proposed on this site. What's happening? I don't see the photo. I don't know anything about the other site. We're talking about what we're doing here. We just had a full night of hearing as to what we're doing on this site.
right. So what's going to
Right.
happen, they're going to be constrained to whatever the testimony that they put on tonight, even if they're doing something different and another piece of property they own somewhere else.
Okay, I understand the cross-examination part, but I thought I was going to be able to bring up some
No,
more
yeah,
questions
you-
about this applicant and their application.
So right now is a general public comment period, so you can put whatever you want on the record. But
Okay.
but you
Yeah, sure.
can't bring in other outside applications that they've done and bring it
Yeah,
into
this
this
is not
one
an
saying that.
application. This is what their operation
Got it.
actually
All right,
is.
So put
So
whatever,
we're not arguing that. I just want to express my concern that what's shown as their current operation is a horrendous mess, and it looks nothing like that. You know, and as an adjacent property owner, our residents there, you have to understand, we already went through the testimony with the D1 variance last time, and now, as far as I'm concerned, we have almost the same application. And in the PM1 zone, the storage with all the dump trucks and the heavy equipment is not a permitted use. It's twisting the regulation.
We will only approve or consider what the testimony has been given to this board for this application. If they do not comply with what is approved for this application, it's a different situation. We
Okay.
only can consider what this applicant has told us they are planning to do. They must abide by what they say they are planning to do.
Understood. And it's just, my concern is once this happens,
Understood.
it's very difficult to do anything about it. There's very little enforcement. So I have another issue with the stormwater, and it's not related to testimony, but to the regulation 244-209 for stormwater. Stormwater specifically will not be recharged if industrial stormwater is exposed to source material. Source material in the definition is heavy equipment, petroleum, and they're going to have these vehicles and source material on the site, and it's going directly to an infiltration basin on the site, right from catch basins. So,
right, so we have a condition of approval that we're not going to allow that.
and again, 244-97A PM1 zone, this application requires a use variance for the equipment owned by Atlantic. They're saying on their application they're not bringing it, but they own it.
All right, because I've talked for a little bit, of just 1 minute warning, and
Okay.
we go from there.
Well, the last point I want to make is, you can disregard the photograph in their current condition. The earlier photograph doesn't look so bad, and that's prior to them being evicted from having all their equipment on a residential property, vacant lot, and then they had to consolidate it all onto that site. And if anything I say is not true, please correct me. But they were land use violators on this site, and I got real concerns. There's just not going to be a good actor here. So I really want the board to be spot on in the approval with the limitations. The last thing I'd request is that buffer line for the limited disturbance have at least a 4-foot chain link fence so that the site doesn't grow. Because that typically happens. Look at the photographs, and even up at the other sites on Whites Hill Road, they're constantly growing into the woods. So if they could fence that line, and then the only other thing I know for a fact is that the Pinelands Commission physically visited the site, and they did look at the LOI markers in that approval. It wasn't just an email or a phone call. They did actually visit the site and verify the actual wetlands lines. So I know there was some confusion about that before, but they did actually come out. So,
All right.
thanks.
Thank you, Mr. Smith.
You swear or affirm to tell the truth, the whole truth, nothing but the truth.
I do.
All right, please state your name and spell your last for the record.
Adam Heidi, Haidi. Couple things I just want to put on the record, or whatever this is. First and foremost, to piggyback off the last gentleman, I'm not sure if this board has the authority to grant the uses that the applicant is testifying. Sounds like exactly what got denied in 2020 from the zoning board. It's a contractor shop, and nowhere in the PM1 ordinance mentions contractor shop. In fact, Donna Jennings told me that warehouses are allowed, but in the ordinance, it explicitly says small goods and products. It doesn't mention vehicles, machinery. It does not. Second, in regards to the debacle, I'm speaking. In regards to,
Adam, you made a point.
can you pause my
Ms.
time?
Jennings is going to refute that point.
Yeah. So the ordinance does not say anything about the size of the goods. It says the warehousing or storage of goods and products, provided that no goods are sold from the premises, and provided further that all items to be stored are within an enclosed building. There's no reference to the size of the goods in the ordinance. I just want to make sure the record was clear.
And that was also a question by our professional at the very beginning of the testimony. And answered.
Well, and just so that we're clear, the zoning officer is the one that renders the determination if something's permitted, not permitted, and then it gets funneled down to whatever jurisdictional board the zoning officer determines it should go to. So by the time it gets to us, it's already been jurisdictionally predetermined what type of use it is. So just so that you're aware, it's not, the board sitting up here making a determination as to what kind of use it is. There's a process that happens before it even gets to the planning board as to what type of bucket it's in. So.
Also just want to put on the record, in the site plan, it again states that this LOI was done by Ian Borden at Professional Design Services. My point was dismissed by Donna Jennings due to me not being an expert. I would argue that Ian Borden's also not an environmental expert, so he had no qualifications to conduct that wetland delineation. Furthermore,
I'd like to refute that because Ian has testified that he has an environmental science licensing. So he is an environmental specialist as well as a planner.
he's not here to testify that, so
Well,
please.
I know him and
But,
I've used him quite often. So
okay.
you're making a statement.
He's not here to
That's
testify, and the
One-
rules
one-
are-
one
he's not here
at
to
a time,
testify,
guys.
not
One at a
allowed to
time.
testify for someone.
One
Thank
at
you.
a time. One at a time.
I'm cross-examining you and pointing out your
Miss-
inconsistent facts.
Miss, just because you speak doesn't mean it's
M-
true.
Mrs. Jennings, if you want to cross-examine them, guys,
Exactly.
all right, if you want to cross-examine them, you can do so afterwards. All right.
And my last point for the record is 244-45. Our conservation overlay zones explicitly state the LOI must be done by the DEP. Nowhere in there, in fact, there is an exception section, letter E, nowhere in there does it mention if the property is within the Pineland zone, the jurisdiction goes to the Pinelands.
Been discussed today in
Quite a
detail.
few.
That's not a fact at all. Another meeting, we're going through this. He makes his own facts up.
Mr. Bresci, let me ask you a
By
question.
Mr. Smith, I'm talking now. so
Use the
please.
microphone.
I am using the microphone. Okay? That's what it is, okay? If you can't hear it, I can't help it.
I think you're being rude. Continue. Mrs. Bresci, you're making
This
quite
has
confident points about this
this has been
conduct, but you don't
detailed.
understand the law yourself.
Okay, all right,
Adam,
all right.
Under the
you're being
jurisdiction of
disrespectful.
DEP, the LOI has been discussed even by Mr. Smith, said that the Pinelands had come out there, and it's been discussed so many times tonight. And I mean, how many times do you have to hear it from everybody before you accept the facts?
Yeah, and what I relate to Ms. Jennings, just because you guys are saying things does not mean they're factual. All I'm asking for is our ordinances to be upheld.
And
I'm not
maybe you
asking
need
for
to
anything special.
understand that state law trumps local ordinances, and maybe being a member of the Environmental Commission,
Right.
you should know what the Pinelands Protection Act is and
Sullivan,
how the Pinelands Commission
Can
works
you point
and
to me
how
where in the
they.
state law, where in the state law does it say that?
Guys, we're not,
Where
we're
in
not.
the state law does our conservation
The,
overlay
Adam,
zone-
the
Can I
Pineland
ask you a
Commission
question?
has their own
Adam?
NJACs,
Awesome.
which trumps everything that we do here.
Okay. One
Adam?
last point I'd like to make. Donna Jennings, when I began to question the applicant whether or not there are wetlands on all 6 lots, Donna Jennings refuted my paperwork that I got from NJ.gov. 3 of the 6 lots explicitly state there are wetlands there.
Right, and
She's correct, all 6 have wetland buffers, but 3 of the lots
Right.
specifically have wetlands on them.
Right.
Adam,
And the
can I
Pinelands
ask you a
Commission will be the
question?
one that
No.
makes that determination.
I'm sorry?
Adam,
I said the Pinelands Commission is the one that makes that determination.
Adam, can I make a suggestion and a question?
Sure.
You're on the environmental committee for the township.
Yeah.
you do a lot of the research and stuff, I'm sure,
Sure.
in preparation for that, right?
Sure,
You talk amongst the other members,
sure.
okay? Why don't you constitute a list of questions before meetings such as this? So that the applicant, the professionals, and the board members can be prepared and to give you actual quotes, not their best.
All right, so,
Great
After
point.
the environmental.
Hey, can I ask you a question?
Yeah,
Did you
Hey,
guys
hey,
receive the
guys-
environmental commission's report
guys,
on
we
this
can't-
application?
we can't have, so
Got
so
it.
you have to be
It has all
testifying,
those
Adam.
questions?
Then why didn't you?
You got to be testifying as just a citizen. You can't be testifying on behalf of the Environmental Commission. So if we go down that route, it's a different
Sure.
ballgame.
I'm just answering a question.
Okay.
Thank you, guys.
Yep.
Let's not anyone else be interested in coming forward.
Seeing no one else come forward, I make a motion to close the public comment portion on this application. Sullivan?
Second.
All in favor?
Aye.
Any comments or questions from this board, from members of this board? Mr. Rogers?
I would like to recommend that the chain link fence requested be considered and added to the approval.
Will the applicant agree to a condition of approval for the chain link fence?
Subject to the Pinelands approval, because I'm not sure they're going to let us put a chain link fence up, but we'll ask.
Whatever kind of fence that
Yes,
the
they
Pinelands
may
agrees
make
to.
us do something different, like a
Right.
split rail or something.
Right.
A little bit more
A
environmentally
delineation,
sensitive.
Mr. Smith, would that be good for you? Some type of delineation?
Thank you.
Thank you, Mr. Rogers. Thank you. You know, this board cannot do 5 or 6 different jobs. It can only do the job that we are allowed to do. We are not code enforcement. We are not the police department. We can only do the job that is given to us with the constraints that we have to live with. One of the constraints we have to live with is the way our system works in this state. The township has its limitations. The DEP has its limitations. And above and beyond that are the Pinelands limitations that are set by the state of New Jersey. We have to stay in our lane. We can only do the job that we are allowed to do. We can't do everybody else's job. Anything from our professionals? Mr. Clee?
Just one thing, and I'll piggyback off of Mr. Rogers. You'll install the fence, you'll ask the Pinelands if they say it's okay, you'll install it. Does the Pinelands Commission know about the floor drains?
I don't know.
When you're asking them about the chain link fence, can you also mention the floor drains?
Absolutely.
Thank you.
Mr. Peters?
Nothing, ma'am.
Mr. Shea?
Just that, going back to jurisdiction, so the board's quasi judicial authority is to enforce the ordinances that are in effect, right? That's where our job is derived from. That's what the board has to do. The outside agencies, they do their own thing in their own way. We're supplementary to them in a lot of ways, them to us. So in this situation, the board has a permitted use in front of it, which is called out by the zoning officer, not by us. There are no variances and 4 waivers. The waiver standard are that of, it's again, it's a 2-pronged process. It's based upon a reasonableness standard, and it's either the condition of the land or the circumstances involved will be enough to grant the waiver. So with that, I'll leave it up to the board to make the decision.
Statement before we move any further. Just to make it clear to people, because I know you have before, we're only the first step in this process. We're not the final step in this process. And ultimately, the final step in this process will be the Pinelands Commission.
Again.
Assume.
One of the steps, yeah.
And I think it is sad that has to keep being repeated and that it's not getting through to some people.
Okay.
All right.
Anything?
Anybody else?
Anyone else? All right. We'll look for a motion, please.
I'd like to make a motion. I mean, going back and forth over the Pinelands, control over this whole site has been done in several meetings. And it's a shame that the public hears other parts that people put out there that is totally false and believe it. I think with all the stipulations you have in there, it's a nice application, a good application. I give you credit for going forward and working with the Pinelands. Good luck with them. They're tricky. But I think it's a good application with the stipulations, with all that involved. I make a motion to approve.
Look for a second.
I'll second that motion and also add that with the stipulations, with the general cooperation of the applicant, this is a conforming and approvable application.
We'll have a roll call vote, please.
Mr. Brezzi,
Yes.
Mr. Marzo,
Yes, providing that all of the conditions, of course, are met and that we can get some kind of a buffer there with a chain link fence or whatever kind of fence, that I would approve that. Yes.
Mr. Heller,
Yes.
Mr. Parks,
Yes.
Mr. Rogers,
Yes, with the provision to note that the zoning was approved, there was no variances, and it's as Mr. Sullivan said, an approvable application.
Ms. Santoro,
Yes.
Mr. Tremor,
Due to the considerations with the floor drains and the environmental impact statements, I'm a no.
Mr. Sullivan,
Yes.
Dr. Campbell.
Yes.
Thank you very
Congratulations.
much. Have a good
Thank you.
night.
That's going to be the third lawsuit against the conservation overlay.
You are out of line. You are out of line. We are still in session, Mr. Hay. Mr. Hay, we are still in session.
I'll accept a motion to adjourn.
I'd like to make a motion to adjourn this meeting. Sullivan.
Second, DeMarzo.
All in favor?
Aye.
Aye.